6 weeks ago, on a Tuesday morning in early September, a 29-year-old kid named Dalton Pryor stood in front of a conference room full of senior engineers and called the structural calculations I'd written over 31 years fossilized math from the slide rule era. He said it with a smirk, the kind of smirk you only see on someone who's never had to defend a single decision in front of a judge or a federal review board. He was the new chief innovation officer at Brennan Holcomb Structural, a firm that had been designing hospital wings, university research buildings, and federal courthouses since 1962. He'd been at the company for 41 days. I'd been there for 31 years and 4 months. The senior structural team in that room was me. I wasn't actually sitting at the table. I was on speakerphone from my office down the hall because the new CIO hadn't bothered to invite me. You can probably do the math on how that was going to play out. My name doesn't matter much for the story, but for the sake of the telling, I'll just say I'm the kind of man who keeps every employment document I've ever signed in a fireproof box in the back of a closet, alphabetized, with the original signatures still legible. My wife Annette has always said, it's a sickness. I prefer the word habit. It's the same habit that, 6 weeks after that meeting, would end up costing the firm $2.86 million. Let me back up a little. I started at Brennan Holcomb in May of 1994, fresh out of Purdue with a master's in civil engineering and a job offer that paid $41,000 a year. Marvin Brennan was still alive then. Marvin was the kind of man who hired you based on a handshake and watched you for 3 months before deciding what he actually thought of you. He took me under his wing because, he said later, I asked the right kind of questions. I didn't try to impress anybody. I just kept asking why. Why this rebar spacing? Why this load distribution? Why this connection detail? He used to laugh and say, son, you're going to be a pain in somebody's neck for 40 years. He was almost right. It's been 31 years and counting. By 1998, I was leading the structural team on the children's wing at St. Vincent's in Indianapolis. By 2003, I'd developed the proprietary modeling system that the firm still uses today for seismic load calculations on medical facilities. It's a hybrid approach, takes about 11 years of practice to use properly, and it has been validated on 47 different hospital projects in 12 states. Insurers love it because it gives them numbers they can trust. The state of Indiana wrote it into their reference standards in 2009. The federal GSA started requiring our methodology for any new VA hospital construction in our service region in 2014. That's not me bragging. That's me telling you why what happened next was so monumentally stupid on the part of the new CIO. Now, about the new CIO. Brennan Holcomb was bought in March of last year by a private equity outfit out of Chicago called Carsten Maitland Capital. The Brennan family had been looking to exit for a while. Marvin's son had no interest in the firm, and the daughter, who actually had been an engineer at one point, had moved to Oregon to raise alpacas. So Carsten Maitland bought controlling interest, and within about 10 months, they'd cleaned house in the executive suite. New CEO, new CEFO, new Chief Innovation Officer. The CIO position didn't even exist before the acquisition. They invented it, near as I can tell, so they'd have somewhere to put Dalton Pryor. Dalton was the nephew of one of the Carsten Maitland's senior partners. I want to be careful here, because I don't want to come across as a bitter old man who hates young people. I don't. I've trained probably 60 or 70 engineers in my career, most of them younger than my own children, and a fair number of them are now running their own firms and doing fantastic work. Some of them still call me on their birthdays. 2 of them named kids after me, which still makes me a little uncomfortable when I think about it. But Dalton was different. Dalton had a master's in something called innovation strategy from a school I'd never heard of, and his prior work experience consisted of 2 years at a fintech startup that went bankrupt and 18 months as a thought leader in residence at a consultancy in Austin. He had never stamped a drawing. He had never been deposed in a structural failure case. He had never had to explain to a hospital administrator why the new MRI suite was going to be 6 inches lower than originally promised because of the loads from the equipment above it. He had, however, given a TED-style talk at a regional conference about, and I quote from his LinkedIn, disrupting the calcified frameworks of legacy engineering. The first time I met him was July 14th in the break room. He came in wearing one of those quarter-zip pullovers that all the young executives wear now. the kind that costs $300 and looks like a sweatshirt. He stuck out his hand and said, "You must be the famous one." I shook his hand and said something polite about being glad to have him on board. He looked at me for just a second too long, the way someone looks at an antique they're trying to figure out the resale value of, and then he said, "I'm going to be doing a lot of listening tours. I'd love to get on your calendar." He never got on my calendar. 41 days, never put a meeting on my calendar. What he did instead was schedule what he called innovation working sessions with a rotating cast of junior staff, mostly people under 30, and started telling them that the firm's methodology was ready for a generational refresh. I heard about this from Marsha, who runs the front desk and has worked at Brennan Holcomb longer than I have. Marsha hears everything. Marcia told me on a Thursday afternoon in August that Dalton had been showing junior staff a slide deck that called our seismic modeling approach, and I'm quoting directly, "Boomer spaghetti." I want to tell you that I laughed when I heard that. The honest answer is that I did laugh for about 3 seconds, and then I went back to my office and shut the door and sat there for a long time. Not because the insult hurt. The insult was so dumb that it couldn't really hurt. What bothered me was the realization, very calm and very clear, that this young man was about to do something extremely foolish, and there was nothing I could say in a meeting or an email that was going to stop him. He was going to have to learn the way some people only ever learn, which is the hard way. So I did what I always do when I see trouble coming. I went to the closet, I pulled out the fireproof box, and I found my employment contract. The original Brennan Holcomb employment contract, the one I signed in 1994, has a clause in it that Marvin Brennan put in personally. Marvin was paranoid about losing senior engineers to competitors, and he was also a man with a deep moral streak about how you treat people who give you their working lives. So he had his lawyer draft a clause, section 7.3, that applied to anyone who reached principal engineer status at the firm. The clause said in plain English that if a principal engineer was terminated without 120 days of written notice and without documented cause reviewed by an outside engineering peer panel, then all proprietary methodologies, modeling systems, and design libraries that the engineer had personally developed during their tenure would revert to the engineer as personal intellectual property. The firm would lose the right to use them. The firm would have to license them back at fair market value or rebuild equivalent systems from scratch. I want you to understand, this clause was not standard. This was not boilerplate. This was Marvin Brennan in 1994 telling future owners of the firm, "You take care of the people who built this place, or you lose what they built." It had been reviewed and reaffirmed in every contract revision I'd signed since, the last one being in 2019. I had a hard copy. I had a digital copy. I had it in 3 different cloud backups because I'm the kind of man who keeps backups of backups. I'm not sure Dalton Pryor knew that clause existed. I'm pretty sure the Carsten Maitland legal team knew it existed because it would have come up in due diligence. But Dalton had not, as far as I could tell, ever read an employment contract in his life, including possibly his own. The Tuesday morning meeting, the one I mentioned at the start, was supposed to be a technical modernization roadmap session. I'd been told about it by my direct reports the day before, after they'd been invited and I hadn't. I asked Joel, our director of structural engineering, and a woman I've worked with for 19 years, why I wasn't on the invite. She looked at me for a long moment and said, "I asked. He said it was strategic, and you'd be looped in afterward. So I made a request. I asked Joel to dial me in on speakerphone. Just listen only. I wasn't going to interrupt. I just wanted to hear what was being said about the work I'd built." She agreed. What Dalton said in that meeting, while I sat in my office with the phone on mute and a yellow legal pad in front of me, was that the firm needed to sunset the legacy modeling stack within 90 days. He said the seismic methodology, my methodology, was a black box that nobody under 40 can maintain. He said it was an embarrassment when we go pitch federal work. And then he said the line that I wrote down in capital letters on my legal pad, underlined twice. He said, "It's boomer spaghetti. It's the kind of thing you keep around because the guy who wrote it is too proud to let it go. But the guy is going to retire eventually, and we don't have to wait." There was a long silence after that. I could hear Joel breathing on the other end. I could hear someone, I think Ramon from the structural team, clearing his throat. And then I heard Joel's voice, very calm, say, "Dalton. He's on the line." And then I heard the kind of silence that you only hear in a room where someone has just realized they've made a serious mistake. I didn't say anything for about 10 seconds. I let them sit in it. Then I said, "Thanks everybody. Joel, can you send me the meeting deck when you have a chance?" And I hung up. I sat there for about 20 minutes. I didn't move. I didn't open my email. I just sat and thought. Then I picked up the phone and called my lawyer. My lawyer's name is Garrison Pell. He's a guy I went to high school with in Lafayette, and he's been my personal attorney since about 2001. He does construction law mostly, contracts and disputes, and he has the kind of dry, slow voice that puts opposing counsel to sleep right before he eats them alive. I told him what had happened. I told him what had happened. I told him about the meeting. I told him about the boomer spaghetti comment. And then I asked him, Section 7.3, still good? Garrison was quiet for a moment, and then he said, "If they fire you without the 120 days and without an outside peer review panel, you walk out with the seismic system, the modeling library, the modeling code, and any derivative work product. They lose the right to use it on any active project. They have to license or rebuild. Yes. Still good. Beautifully good." I asked him if he thought they'd actually fire me. He laughed and said, "Friend, you said he called your work boomer spaghetti in front of 9 witnesses. He's going to fire you within 2 weeks. He has to. Otherwise, he looks weak in front of the people he's trying to impress." Garrison was off by 3 days. They fired me 11 days later. The call came on a Friday afternoon at 4:17. It was the new CEO, a man named Ashton Crew, who'd come over from the private equity side and who, as far as I could tell, didn't actually know what our firm did beyond the revenue projections. He asked if I had a minute. I said I did. He thanked me for 31 years of service. He used the phrase strategic realignment of our senior technical leadership. He said the firm had decided to move in a new direction and that I would receive a generous severance package, which he described as well above market. He said the effective date was the end of the day. He said HR would be in touch on Monday with the paperwork. I asked him one question. I asked, "Is this termination with cause or without cause?" There was a pause. He said, "Without cause. This is a strategic decision. There's no issue with your performance." I thanked him. I told him I'd been honored to work at Brennan Holcomb, and I hung up. Then I called Garrison. Garrison said, and I'll never forget this, did he say, "without cause" on the phone? I said yes. He said, "Without cause" on the phone? I said yes. He said, "Was anyone else on the line?" I said, "I didn't know." He said, "Doesn't matter. Get the termination letter from HR on Monday and bring it to me. If it doesn't reference cause and a peer review panel, we are going to have a very expensive Tuesday." I went home. I told Annette. She made me a bourbon and looked at me for a long moment and said, "How bad is this going to get for them?" I said, "I think it's going to get bad." She nodded and said, "Good. I want to take a second here to be clear about something. I was not happy. I want to be honest with you about that. There is no version of being fired from a firm where you spend 31 years of your life that feels good, even when you know you're holding the card that's going to flip the table." I drove home that Friday afternoon thinking about Marvin Brennan, who'd been dead for 9 years, and about all the projects, the children's hospitals, the research labs, the community college campuses that I'd had a hand in. I thought about the engineers I'd trained who'd moved on to other firms but still called me sometimes. I thought about my office, which had a window facing east, where I'd watched the sun come up over the parking lot for 3 decades. I was not happy. I was something else, something colder and more patient. Monday morning, the HR letter arrived in my email. It was 3 paragraphs long. It cited strategic restructuring as the reason for termination. It offered a severance of 6 months' salary contingent on signing a release of all claims. It made no mention of cause. It made no mention of a peer review panel. It made no mention of 120 days of notice. It was, from a legal standpoint, the dumbest piece of paper I had ever seen in my life. I forwarded it to Garrison. He called me 40 minutes later and said, "Tell me you have all the documentation on the seismic methodology. Tell me you have the development notes. Tell me you have the version history." I said, Garrison, I have everything. I have every version going back to 1996. I have my personal lab notebooks. I have the validation reports. I have the timestamps. I have it all in a vault at First Hoosier Bank. He laughed. He actually laughed out loud on the phone. He said, brother, they are going to choke on this. What happened next happened over about 3 weeks, and I'll try to give you the highlights. First, Garrison drafted a letter to Brennan Holcomb and to Carsten Maitland Capital. The letter stated that, pursuant to Section 7.3 of my employment contract, all proprietary methodologies developed by me during my tenure had reverted to my personal ownership effective the moment of my termination, without cause and without the required notice period. The letter identified the seismic modeling system, the medical facility load distribution library, the connection detail database, and 17 specific derivative methodologies, all of which were currently being used on, as of that date, 23 active projects at the firm, including a federal VA hospital expansion in Bloomington, 2 children's hospital wings, and a research building at Indiana University. The letter requested that the firm immediately cease use of these methodologies on all active projects pending resolution of licensing terms, or, in the alternative, that the firm enter into good faith negotiations for retroactive and prospective licensing. The letter, when Garrison read it to me before sending, made me laugh harder than I'd laughed in years. There's a line in there, I'll never forget it, that says, failure to cease use of the aforementioned methodologies on active federal contracts may additionally implicate compliance obligations under federal procurement regulations, which my client respectfully suggests your counsel review at the earliest opportunity. Garrison said that line was free of charge. He said he just enjoyed writing it. The letter was sent on a Wednesday. The first response from Brennan Holcomb's general counsel came 2 days later. It was a very polite, very confused email asking for a meeting to discuss the matter. Garrison wrote back and said he was happy to meet and that he would also appreciate the courtesy of being told whether the firm intended to halt use of the methodologies in the interim. There was no response to that question for 4 days. On the following Tuesday, Garrison got a call from a partner at a downtown Indianapolis law firm. This was Carsten Maitland's outside counsel. The conversation, Garrison told me later, lasted about 90 minutes and consisted mostly of the outside counsel trying to figure out whether Section 7.3 was actually as bad for his client as it appeared to be. Garrison's answer, summarized, was, yes, it is, and it's worse than you think, because 3 of those active projects are federal contracts with specific methodology, references in the statements of work. The reason that mattered was this. When Brennan Holcomb pitched federal work, particularly VA hospital work, the firm specifically cited my proprietary methodology as part of the technical qualifications. It was in the proposals. It was in the contract documents. The federal agency had relied on the representation that the firm had the right to use that methodology. If the firm no longer had that right, then the firm was potentially in breach of the federal contracts, potentially worse, depending on how aggressive the federal contracting officers wanted to be about it. I was not the one who raised that issue. I want to be clear about that. Garrison raised it, very gently, very politely, in the course of explaining why his client would prefer to negotiate quickly rather than go to court. He suggested in his slow, dry voice that perhaps the firm and its new ownership had not fully appreciated the federal contract implications of terminating a principal engineer without cause and without notice. He suggested that perhaps a quick settlement, including a retroactive licensing fee and a prospective licensing agreement, would be in everyone's interest. The number Garrison opened with was $4.2 million. $2 million for retroactive use on active projects, $1.5 million for a 5-year prospective license, and $700,000 for the firm's failure to provide the contractually required notice period. The outside counsel laughed at the number. Then he stopped laughing about an hour later when his junior associate finished pulling the federal contract language. He called Garrison back the next morning and asked if there was any room to negotiate. There was. We settled on $2.86 million. The breakdown was $1.4 million in retroactive licensing, $1.1 million as a 3-year prospective license, and $360,000 for the notice period violation. The firm also agreed to issue a written acknowledgement that the termination had been without cause and that my work product was proprietary to me personally. That written acknowledgement is the kind of thing that doesn't have a dollar value, but you can't put a price on it either. It's a piece of paper that says, in plain language, the firm was wrong. The check arrived on a Thursday, 6 weeks after Dalton Pryor first stood in that conference room and called my work Boomer Spaghetti. It was issued by Carsten Maitland Capital directly, not by Brennan Holcomb, which I thought was interesting. The exact amount was $2,184,217.83. The 83 cents was, Garrison told me, a calculation related to per diem interest. I framed the check, photographed, before I deposited it. It hangs in my home office now, between a picture of Annette and a picture of the Children's Hospital wing at St. Vincent's. Now, the aftermath. Dalton Pryor was fired 13 days after the settlement was signed. I didn't ask for his firing. I didn't even bring it up. Carsten Maitland fired him on their own initiative, and the reason, as far as I've been able to piece together from former colleagues, was that the senior partner who was his uncle was extremely embarrassed by the whole situation and wanted distance. Dalton's LinkedIn now says he's a fractional chief strategy officer at a consultancy in Phoenix. I wish him well. I genuinely do. I hope he learns something from this, although I'm not optimistic. Ashton Crew, the CEO, is still at the firm. But the word from Joel and from a couple of other folks who still talk to me is that his honeymoon is over. The board has apparently decided that someone needs to take the fall for the loss, and Ashton is the one whose name is on the termination decision. Brennan Holcomb still uses my methodology under the licensing agreement, and they pay me a quarterly royalty. The first royalty payment, last quarter, was about $41,000. The licensing agreement runs 3 years, after which we'll renegotiate. Garrison has already told me to expect a tougher negotiation next time, because by then they'll have had time to try to develop alternatives. I told him I'm not worried. The alternatives take 11 years of practice to use properly. They have 3. Here's the part of the story I want to tell you about, though, because I think it's the most important part. About a month after the settlement closed, I got a call from Joelle. She asked if I would consider coming back as a part-time consultant, not as an employee, not under contract, just as a paid technical advisor on the federal projects billed hourly with no obligation of any kind. She said the firm needed someone to act as the methodology custodian for the active VA hospital work, and that the federal contracting officer had specifically asked whether I was available. I thought about it for a week. I talked to Annette. I talked Garrison. I talked to my pastor, which probably sounds strange, but my pastor and I go fishing together, and he's good at asking questions that cut through. He asked me a question that I want to share with you. He asked, is the answer no because of pride, or is the answer no because of wisdom? The honest answer was, I didn't know. I thought it might be pride. So I said yes. I went back, in a manner of speaking. I bill the firm at $12.50 an hour with a retainer of $75,000 against future billings. I don't have an office at Brennan Holcomb. I work from my house and I drive into Indianapolis once every 2 weeks for technical reviews. I report to Joelle, who I've worked with for 19 years and who I trust completely. I never see Ashton Crew. I never go to the executive floor. When I walk into the building, the receptionist, Marsha, hugs me and I drop off a box of donuts from the place on Massachusetts Avenue that Marvin Brennan used to like. I want to tell you one more thing and then I'll wrap this up. About 2 months after I started consulting, I was sitting in a technical review on the Bloomington VA expansion. There were 8 engineers in the room. I was leading the meeting. I was talking through a connection detail for the 3rd floor surgical suite where we had to manage some unusually heavy equipment loads. About halfway through, a young engineer, a kid named Pratt, maybe 26 years old, raised his hand. He said, "Sir, can I ask a question?" I said, "Sure." He said, "I've been studying your modeling approach for the last 3 weeks. I think I understand most of it, but there's this one piece in the load distribution module where you do a non-standard transfer through the floor diaphragm. I can see what it does, but I can't figure out why. Can you walk me through it?" I looked at him for a moment, and I thought about Marvin Brennan sitting in a conference room in 1994, looking at a 24-year-old kid who kept asking why. I said, "Sit down. This is going to take about an hour. You got an hour?" He said he did. I walked him through it. And about 40 minutes in, I realized he was going to be very, very good at this someday. I'm telling you this because I want you to understand what the revenge actually was. The revenge was not the check. The check was nice, and I'm not going to pretend it wasn't. The revenge was not the firing of Dalton Pryor. That happened, but it wasn't something I did. The revenge wasn't even the written acknowledgement that the firm had been wrong, although that's the piece of paper I'm proudest of. The revenge was being right. The revenge was being there. 3 months after I was supposed to have been put out to pasture, sitting in a conference room teaching a kid who actually wanted to learn how the work gets done. The revenge was knowing that the methodology I'd built was going to outlive me, because somebody finally had asked the right kind of question. There's a thing about people like Dalton Pryor. They don't usually stick around long enough to see the consequences of their decisions. They move on to the next job, the next title, the next quarter zip pullover. They never quite figure out why their grand schemes don't pan out, and they never quite figure out that the people they dismissed as boomer spaghetti were the people holding the building up. I'm not bitter. I want you to know that. I'm not bitter at all. I had a Friday afternoon a few weeks ago where I drove home from Indianapolis with the windows down and the radio off, and I thought to myself, this is the best I have ever felt about my career. 31 years and a few months of work, and the best part of all of it has been the last 60 days. A lot of people will tell you that revenge is a dish best served cold. I don't disagree with that, but I think they leave out an important part. Revenge is best served by being the person they should have listened to in the first place. And then, when they finally come back, being the person who's still willing to teach. That's the part Dalton Pryor never understood. That's the part the new owners are starting to understand. And that's the part, if you're still listening, that I hope you take with you. Take care of your contracts. Keep your backups. And when somebody calls your life's work spaghetti, smile and go find the page that proves them wrong. I've been turning this whole thing over in my head for a few months now. The way you turn over a stone in your pocket when you're sitting alone at the end of a long day. And what I keep coming back to is this. None of what happened to Dalton Pryor was something I did to him. Every consequence he faced was a consequence he built himself, brick by brick, over the 41 days he was at the firm. He chose to dismiss work he didn't understand. He chose to insult people in rooms he thought were private. He chose to fire a principal engineer without reading the contract he was firing him under. Cause and effect. That's all it ever is. You plant the seeds, you eat the harvest, and there's no manager and no private equity firm in the world that can change that arithmetic. I think about my own choices in this whole business too. I had decisions to make at every stage. I could have walked into Dalton's office the first week and confronted him. I could have leaked the contract clause to him as a warning. I could have, when I was fired, signed the severance paperwork and gone quietly and saved everybody a lot of grief. I didn't do any of those things, and the reason I didn't is the same reason Marvin Brennan hired me in 1994. Patience, discipline, the willingness to do the boring work of keeping good records and waiting for the right moment. None of those are flashy virtues. None of them get talked about in TED Talks, but they're the ones that pay out, eventually, every single time. What I want my grandchildren to take away from this, if they ever hear about it, is not the check. The check is the smallest part of it. What I want them to take from it is that character is something you build over decades, not something you perform in a single moment. Annette has always said that you can't borrow integrity. You either have it stocked up, like firewood in the back shed, or you don't. And when the cold comes, you find out which one you are. The young engineer named Pratt, who sat in that conference room and asked me to walk him through the load distribution module. That kid is going to be a better engineer than I ever was. And the reason is not that he's smarter than me, although he probably is. The reason is that he asked the question. He had the humility to admit he didn't understand, and the courage to say it out loud in front of 7 other engineers. Those two things, humility and courage, are the whole game. Dalton Pryor had neither one. Pratt has both. If you take anything from a long story told by an older man, take this. The work matters. The contract matters. But the person you become while doing the work, that's the only thing you actually keep. Everything else, even the $2.86 million, eventually gets spent.